party action against direct action against the company that actually took out the policy. Then you bring in the insurance policy. I don't know. But those are some things you have to look towards. But carefully now look at the commencement of proceedings against for recovery or enforcement of insurance policies. This is what now you should be looking at. What is the best way to commence? Who is the active party to the proceedings? Are they the third parties? These are some of the questions now we should be asking ourselves as parties to litigation. This is the 2016 dispute, Salini Construction versus Jubilee. I don't know whether the CEOs of these companies are all here, but these facts are these are facts which we are court of record, the High Court. So they are all. So this case arose when an insurance contractor claimed under marine policy after ski bars shipped from Turkey degraded when the vessel developed mechanical problems. The court found that the issue with the insurance policy was challenged on grounds that the ship, the age of the ship was paramount to the policy, and it had not been disclosed and that kind of thing, and it was older than it was actually supposed to be. Court found otherwise and upheld the policy that the violations that were sought were not accepted. This is Haji Kapuma and First Insurance Company. Again, this is goes to non-disclosure of issues at the point of entering into insurance contracts. The party failed to give full disclosure, and it's very paramount. Failure to give full disclosure where required, or the nature of disclosure led to the rejection of that claim for the insurance. The vehicle was damaged. National Housing Construction versus Lion Assurance Company. This was based on an APG, and it really rotated around what was the actual APG that was supposed to, the insurance was supposed to have been paid for. And the court found that it wasn't the one that was purported to have been. National Insurance Corporation versus Kalungu. This is again relating to misrepresentations. And the issue was disclosure. Scorpion Insurance, fire damage. Court held that alleged non-disclosures were immaterial to the policy. Extent of disclosure. Nakiseki Insurance. This is where the insurance rejected the claim. This was a medical insurance claim, I believe, the death, and court found otherwise. Court found that the allegations by the insurance company that the person was not the one who was examined, amongst other things, was held not to be true. 𝑪𝑬𝑶'𝑺 wire products. This is also another claim which court upheld for loss of goods in transit. Now, these are just a number of cases. I'm not going to go through each one, but I listed them. I believe they'll be able to access these decisions. Mudisha, that is another motor vehicle insurance claim. Now, I'll go to issues that trends from reviewed precedents. This is, the balanced application of the duty of utmost good faith. These are the things that are really, expected. And court will really try to uphold those decisions, those positions, as a person acting in utmost good faith in performance or in honor his obligations under the insurance contract. Disclosure of duties are now viewed as reciprocal. Each of you owes a duty. It's not just me who takes out an insurance policy, but the insurance companies also owe a reciprocal duty to the insured to honor the insurance in the time when the event actually happens. It will be important for you. I don't know whether the insurance industry has the insured, whether you make follow-ups with your insured clients every so often to find out, are they complying with the insurance policies? Are certain things that they've undertaken, are they operational? It could be as areas you could look into as you try to ensure that there is a compliance with the insurance policy that has been undertaken. High evidentiary threshold for insurance defenses. The threshold for insurance defense is high. Fraud is at a high level. Therefore, it must be proved to that high level. It's not enough to just say there was a fraudulent action in this. So we must, as a litigant and insurance, you must show that there was actually fraud on the part of the person who's trying to take advantage of this. The decisions I've cited to lead to that one. Preference for substance over form. Courts will prioritize genuine consent and fairness over technicalities. That's generally, you see, focusing at all times on the reality of contractual relationship. There's a bit of a departure from the element of technicalities, which is where the courts and justice is actually going. Article 126 of the Constitution. We try to see what is actually just in this issue. It's not going to say, there's a position, let's leave it and leave it. So we have to have that insight as well. Now reading of subrogation, because subrogation is a contract for indemnity and not profit. Court will prevent recovery beyond amount paid. Courts will now occasionally grant general damages for bad faith, delayed payment of claims, and repudiation. If the insurance company is found to have acted in bad faith, you could end up incurring a cost, an additional cost for that action. And this already talked about the now reading of subrogation. These are areas where we find what are the causes of disputes between the insurers and the insured. Construction of the policies, where there's a vague policy, there's not clear understanding of how and when it will arise. Errors in claim assessment, especially undue denial of claims. You have a lot of issues concerning when was the notification given, what was the nature of notification, who did you notify. Those are some of the issues which come into play. Somebody sends an email to another person, and the person sends an email and because in that they say the elements of when was the notification given for, it becomes an issue. Allegations of policy non-compliance, late notification, this is what I've just been talking again. Allegations of fraud, we discussed. Disagreements over liability and quantum when it comes to loss assessors. Who's the loss assessor to be relied on in this case? And delays in claim management. At times you find the insurance companies, there's just an unnecessary, unexplained delay in actually managing the claim that has Failure to comply with the dispute resolution process, filing in the wrong forum. We've already talked about this. Now, a case cannot come to the commercial court directly in a dispute between two insurance, a claim against the insurance company, or the insurance nature. It only comes to the by way of appeal. Non-compliance with the enforcement procedure, third party suing an insurer directly before establishing claim against the insured. We've also talked about. These are some of the issues which we can look at, or which you should look at. Lack of diligence in prosecuting suits, leading to delays, objections, or dismissals. Failure to comply with claims procedure and the policies, improper pleadings, incomplete and inconsistent documentation. This is a very, very challenging issue. Documentation. Documentation. I will stress that documentation. A claim is based on documentation. When you lose the trail of the claim, it causes a lot of challenge. What is it? What are the steps? What was the action that was supposed to be taken? What was taken at the required point? Those are issues that are not properly addressed at some points. These are what are termed as common procedural evidentiary pitfalls, failure to link quantum claim to evidence, loss assessment gaps, hearsay problems, inadequate witness evidence, limitation problems, failure to specifically plead and prove insurance exceptions such as fraud, poor case management, and I'll now go to what I think I would say like best practices. This stems from the challenges you have. Okay? So best practices, clear policy language, use of simple, unambiguous language in policies to ensure clarity and to reduce legal disputes. Full disclosure of requirements. Disclose all material facts clearly as a policy inception and renewal to uphold transparency and compliance. Defined exclusion clauses. Include well-defined exclusion clauses in policy to reduce litigation risks and clarify. Sorry. Exclusion of limitation clauses. There's also standardization of clauses in the industry. And I'll not go, I prepared this, but I don't think it's really necessary for us to discuss. I said this is a live discussion, but you can share, you'll be able to look at that aspect about it. So, as I come to the end, I hope I've been able to highlight to you what the nature of insurance disputes are in the commercial court, how we're handling them, how you could also participate in the possible resolution of these disputes. ADR, I will not leave this podium without talking about ADR because it is going to be a big game changer when it comes to dispute resolution. Where possible, explore the possibility of seeking alternative dispute resolution. It is cheaper, it is faster, you have the opportunity to make that decision by yourselves. Leave the egos out of the room when you come to this for ADR. That's a fact, by the way. And many a times people come for dispute resolution when each one feels the approach should be, let me hear out what this person has to say. The person's dispute may be, I just need time to pay. Banks lately have become a bit, I do appreciate the banks say that here, lately they've become a bit more susceptible to hearing, resolving a dispute, because at the end of the day, you may get a judgment and it's on paper. You can't enforce it. Why not try and get a way of managing a situation where you're able to recover what you can? I'm not saying that you're not entitled to recover, you're entitled to recover. But the issue is, how long will it take you to recover, and what will you actually recover? So with that, ladies and gentlemen, distinguished CEOs of the industry, of insurance, and those of banking present, allow me to say that is where I end today's interaction with you in regard to my presentation. Thank you.
Thank you so much, Your Lordship, for those insightful comments and insightful presentation that you've made to us. I think what I've picked out, amongst all, I've taken down notes, a lot of notes, and I'll be referring to the Complaints Bureau. But most importantly is, insurers must have a robust and fair claims determination process. Avoid near automatic rejection. I think one of the things that we noted is that insurers do automatic rejection sometimes, and some of the people that we get in the Complaints Bureau, it's actually just managing emotions. It's not really a complaint, it's not really a dispute, but it's because the insurer handled them so badly. The client decided, I must report this person. So it's important that you avoid that near rejection, so that, because some of these things can be diffused by just being nice to the client. And actually some of them just admit and say, okay, now I understand, I'm sure I didn't explain anything, especially when you just reject. So colleagues and captains of the industry, please manage these complainants at that level as well. So thank you so much, Your Lordship. We've learned a lot, and I'm going to request for questions at this time. Do we have any questions? We must have questions, because we have 9 billion locked up in courts. I don't want to say how much is locked up in the Complaints Bureau, but we are trying our best to drive the traffic out. Yes, sir. Do we have another microphone?
Good morning, everyone. Thank you to the Chief for organizing this very informative session. My name is Andros from ICLI. 2 questions to the Honorable Judge. One question we need to answer is, how long does a case take in the commercial court, and what efforts are being made to battle and reverse the growing case backlog? I ask this question because recently we had a matter ruled after 8 years, and if we paid this claim, we would have paid 400 million, and that would be it. But spurious demands were made by the litigant, or up to the tune of 8 billion. In the end, they got only 7 million after 8 years, but the legal fees were north of $100,000. So you find that the only winners are legal counsel. The effect of winning is negated by the cost of litigation. So my two questions are, why then can't we widen the bench, have more of you to dispense of these matters? And two, how can we make it more equitable in terms of the fees that we pay to legal counsel? I know if you were on the other side, you wouldn't answer that question easily, but now that you're the other side, you could give guidance, because my ultimate liability in contract in that matter would have been 400, but now I'm paying legal fees almost of the same amount, even after winning. Is there a remedy for that? Thank you.
Can we take just 2 more, and His Lordship responds to them? We have one here.
Thank you, Alan 𝑪𝑬𝑶'𝑺. Mine is with respect to project evidence on fraud. Factual and clear. The challenge is, I don't know the information in the legal circles, that fraud is so prevalent in the industry, not just in Uganda. But then, if the laws are designed, quote, protect fraudsters, that it must be extreme clear, whatever evidence is, evidence is called it, would not be a challenge for the industry, because it's not a secret. Thankfully, thrown out and they don't go to court, because they know that. But when they see such judgments, if any, and hear the arguments, it definitely is going to affect the industry. And the regulator will be supporting us in that space, and that's why he started the unfair base. How can we be supported by the legal system? Thank you.
One more at the back.
Good morning, colleagues. Thank you, Aaron, for bringing us together. Your Lordship, I have one simple question. In cases where a matter goes to appeal beyond maybe the court, where maybe a party is lost a case, and then you are asked to pay the ticket amount pending appeal, how long does it take after, say, you win the appeal to recover that money? Thank you.
Thank you very much. Your Lordship, we have 3 questions. Please look at your tables. We have this kind of paper. Please scan and give your feedback about the presentation, but also the discussion today, the topical discussion today. Your Lordship, the insurers want their money out of court. Over to you to respond to the questions.
Thank you. Hello? Okay, let me use this one. How long does a case take in the commercial court? It's not easy for me to answer that question, but it really depends on a number of factors. We try to ensure that a case is disposed of within at least 1.5 to 2 years from the point of filing. It is not always successful because there are so many factors that come into play during the proceedings. At times, it's the litigants who are intentionally delaying the proceedings. I personally normally tell counsel who appear before me that we have the unfortunate experience that I have crossed over from that point to this one. Therefore, all the tricks, I probably used them also. But the idea is really at times we do try to have a disposal between 1 to 2 years. At times it spills over. Now the one we are saying 8 years, I don't know exactly which matter it was, but you may find that it may have had a series of, they had a change in a number of judges were transferred, and as a result of that, you'll find a new judge coming on board and commences the hearing. Then in the process, that judge is transferred and another judge comes on board, and this causes some of those delays. But I do know that efforts are being made by the judiciary to try and have a more robust and concise judicial body, whereby we are more confined to a duration of the case. So I don't know if now we have that number of the oldest case. I'm not sure of the exact date of the oldest case. We used to have a couple of cases which are a bit old, but these are likely going to be disposed of. We are also assured, we've been assured by the judiciary that they intend to give 2 more judges to the division. We used to have 10, but in the process 2 were transferred, and we're now, actually it was 5, went to 8, we went to 10, 8, we're now at 8. And hopefully we'll have 2 within the next year to make it 10. And if that get an additional 10, I personally have about, in my docket, about 660 cases. 660 cases. And as I said, I can, in a good month, I can conclude 50 cases, but I'm assigned an additional 60. I hope that can give you something. So I hope that answers both the case backlog and as well as the duration. Now the issue of cogent evidence, we are actually bound by the provisions as to what the value, the strength, the weight, proof of fraud. There's a legal threshold. You can't just come to court and say there's fraud. You must be able to take the fraud to that threshold to show this person actually acted in a manner that was fraudulent. You can perceive the fraud that was actually carried out. So to issue the issue, it has to be specifically pleaded for you to be able to appreciate what is the fraud. You are supposed to have done ABC. It was supposed to be done in this particular way. It was not done. It was done after the fact, and then there was a backdating of something. Those are the ways in which you try to bring out the element of the fraud, and it's brought to the court to be able to appeal. It's able to appreciate that you've reached that threshold. Recovery of costs or an award that has been deposited. Now, one thing we try to do is, when there's an appeal from the court, the commercial court to the court of appeal, we feel at that point we've done our work. Okay? If you owe that person money, pay. Pay the money. If you want to go, you go to the next level and challenge it. So what we try to do is ensure that money, if you come for a stay of execution, say please stay the execution of this case while I appeal, we say we'll give you the stay, but deposit the money here. Many appeals actually do not take off because of that. Not in a bad way, because some of them are nuisance appeals. Some of them are nuisance appeals. Somebody just wants to deprive you of an opportunity to get access. But once you say, pay the money here and go, that's the end of it. And then you say, I'll pay. They deposit it into court. Now, at that point, it's you to pursue the appeal at the next level. The money is in court. Once the appeal is determined at that level, you come and get your money if you're successful. The money is in court. You come and get your money. Because you have paid, the receipts are there, everything is there, you get a court order from the court of appeal, you come and your money is given to you. We don't normally keep I don't know, I hope that's not what is termed as money locked up in court, but that's a method we use to try to ensure that we have done our work. We've decided that the party is actually supposed to be paying another individual this amount of money. You owe that person that money, pay that money. If you want to challenge my decision, pay and go and challenge.
Let me take this opportunity to thank our presenter. Can we give him a round of applause? Thank you very much. Thank you very much, my Lord and my young brother. We've had what we can take home, the alternative dispute resolution. We resolve our issues ourselves. The vagueness of our policies makes things move up to the courts. We should avoid that. Thank you very much, sir, and may I declare the 66th CEO breakfast meeting officially closed. Thank you. And unless it is the school one to talk to you, but I think you are protected. For you, you can move, and for us, we will talk.
Stand.